Okay, good morning, everyone. Thank you for joining us for the Federal Employee Defense Services, or FEDS, webinar on PLI. My name is Samantha. Our President, Anthony Vergnetti, will be providing you all with an overview on professional liability insurance, what's covered in a policy, and why you should be protected. The presenter will also answer questions at the end of the webinar. However, if you do have some throughout the presentation, you're welcome to submit them by typing them in the questions and chat box there on the right-hand side. During the Q&A session, Tony will address all of those questions and then any further ones that you have. Please note that the webinar is being recorded. We're going to keep you guys on mute until the Q&A open forum to avoid the background noise, and then we can send you a recording of the webinar afterwards. At this time, I would like to turn the presentation over to Anthony Vergnetti, President of FEDS.
Thank you, Samantha. Good morning, everyone. As Samantha said, my name is Tony Vergnetti, and I'm the President and Founder of FEDS, Federal Employee Defense Services. And we certainly appreciate this opportunity to provide you with some information about professional liability insurance and our company. And I appreciate Mr. Sullivan and Mr. Marshall organizing this for us. Before we get started, just a little information about me. I am an attorney, but let's not hold that against me just yet. More importantly, I am a former federal employee myself. I worked many years for a federal law enforcement agency, ATF. Then I worked several years defending federal officials, a lot of law enforcement folks, as a partner at my old law firm of Shaw, Bransford, and Roth. So for today, I took our general law enforcement officer presentation and tried to tailor it as best as I could, because as you know, as court employees, at-will employees, the way the rules and the laws apply are just a little bit different than the rest of the government. So I'll try to point those out as we go along. This first slide is just a little fun slide I put together when people ask me why they need professional liability insurance, and it just looks like there's open season on federal employees these days. There's all kinds of examples out there in the press of federal employees being placed under scrutiny, hardworking, dedicated federal employees being put under the scrutiny, which with scrutiny comes increased vulnerability. We're not going to go through this slide. This is just a video we put together of some news clips. So law enforcement officers in general have this trifecta of legal risk, or what I call the gun, the badge, the car. This results in you having increased scrutiny for your jobs. So it's been my experience both in federal law enforcement and defending federal officers for over 23 years that you all have the most exposure. And in fact, it was because of this exposure, the whole concept for PLI was really created. It was initially for law enforcement. And that was also the whole reason that Congress passed the legislation authorizing the reimbursement. So liability exposure for all federal law enforcement employees really began back with this case, the Supreme Court case called Blvens versus 6 unknown federal narcotics agents, which was the very first case that allowed federal employees to be sued personally. So this is not law school. I'm not going to go get into the legal analysis or get into the specifics here. All you really need to know is that you can be sued personally and you can be held liable for monetary damages. Now, as court employees, you do enjoy special immunity called quasi-judicial immunity for certain acts, which operates like absolute immunity. As you know, your judges have absolute immunity. But if you don't qualify for this quasi-judicial immunity, you will only have something that's called qualified immunity for these personal capacity lawsuits, which is still pretty darn good. Qualified immunity essentially means that you will not be held liable if you had a good faith belief that your actions were legal and your belief was a reasonable one. But because there is this possibility that a federal official could be held liable for doing his or her job, this whole idea for professional liability insurance really came about. And again, this was the whole reason that Congress passed the legislation requiring federal agencies to reimburse managers, supervisors, and law enforcement officers up to 1/2 of the cost. And pretty much every court that I know out there is also reimbursing federal probation and pretrial officers as well as supervisors. So at this point, I can't emphasize this enough. This is Congress understanding that you need this protection, and they want you and the taxpayers to share the burden, of the costs with you. They appreciate that you have this potential vulnerability that you could be sued and you could be held liable for just doing your job. So they want to encourage employees to make the decision to get this insurance to protect themselves so that they have peace of mind when they're doing their jobs day to day. It's no different, in my opinion, than any other employee benefit out there that you should be taking advantage of. You wouldn't leave your I think it's 3% TSP match on the table. You shouldn't leave this benefit on the table either. So the coverages, you can think of the coverages in these three basic areas. One is administrative and disciplinary matters, which we'll get into in a little bit, civil lawsuits, and criminal investigations. So we're going to start out with civil lawsuits. These lawsuits are typically called Blvens actions, personal capacity lawsuits, and let me just get this out here. And they usually involve violations of First Amendment, Fourth Amendment. A lot with probation officers, we have a Fifth Amendment deprivation of property or liberty. Get a lot of those claims and a lot of Eighth Amendment type claims as well. So these lawsuits, as I said, are referred to as Blvens actions. You probably heard them referred to as constitutional torts, personal capacity or individual capacity lawsuits, and they generally involve some pretty complicated legal principles. But so for purposes of today's discussion, what I want you to take away is an understanding that you can be sued and you can be denied DOJ representation, and regardless of who's representing you, you can actually be held personally liable. So let's deal with the representation piece of it first. Okay. DOJ representation, whenever we get sued, and what is it we all think about is who's going to defend us? DOJ representation is a two-part test. It's not mandatory and it's not automatic. The first question is whether you're operating within the scope of your employment whenever, doing whatever it is you did or did not do in a particular case that led to the lawsuit. And that's usually answered yes. The second part of the test is it in the interest of the United States to provide you representation? So when does DOJ say no to that? The typical example I give is if you're being investigated, by the court or by the agency for some sort of wrongdoing for the very same reason that you're being sued, you're not going to be, they're not going to be on both sides of that. So that's when DOJ will decline representation at that point. And that's when the Fed's policy will kick in and will provide representation. So you still may have the qualified judicial immunity to assert, qualified immunity for constitutional torts to assert, but you would be required to hire your own lawyer if DOJ was not going to provide representation. This is where a PLI policy kicks in and will provide representation from what I call cradle to grave, from the start of the investigation up into the conclusion of the investigation. Somebody just handed me a note that thinks that you all may not be eligible for the reimbursement. We'll deal with that in the Q&A section later. It's my understanding that all the probation officers are eligible for the reimbursement, but just not the pretrial officers. So that's an important point. So that's representation. You could be denied representation. Policy will kick in and provide representation. Also with representation is we may appoint what's called coverage counsel. In a particularly egregious case, where we got fatalities, dead bodies, and things like that, we may assign coverage counsel to oversee what the representation of what Department of Justice is doing. We're not totally overseeing it, but we just want to keep our hand in it and make sure that your interests, and our interests are being looked out for. We also may appoint coverage counsel in the event that DOJ is on the fence as to whether they'll represent you. So we know all these people in Maine DOJ who kind of make these decisions, and if they're on the fence, we'll hire coverage counsel to kind of go in there and convince them that it is in the interest of the United States to provide representation. Because at the end of the day, while the policy would provide representation, at the end of the day, we are all better off if the U.S. government stands up in court and is representing you. So the next concept I want to deal with is immunity. So you don't have absolute immunity for these personal capacity lawsuits like you do for lawsuits under the Federal Tort Claims Act. These are intentional torts. So any of these kind of common law intentional torts, you have absolute immunity for, but you do not have absolute immunity for these constitutional torts or personal capacity lawsuits. So as I mentioned before, you would either have quasi-judicial immunity or you would have qualified immunity. Quasi-judicial immunity, which essentially operates as absolute immunity so long as you're operating in good faith, is recognized for probation officers who are sued for performing tasks intimately associated with judicial phase of the criminal process, like preparing a pre-sentencing report. That uniformly gets absolute immunity. Whereas such things as initiating probation, supervised release revocation proceedings, or seeking an arrest warrant are not going to be entitled to quasi-judicial immunity. The Supreme Court has established a six-factor test to help this analysis, but rather than do some legal gymnastics on those 6 factors, the clearest way to kind of explain it is the more you are performing in a traditional a law enforcement police role, as opposed to a judicial role, the more you are performing like a police officer, the less likely you're going to have the quasi-judicial immunity at your disposal, okay? So you're putting your hands on somebody, you're serving an arrest warrant, you're incarcerating them, you're revocating their probation, things like that. You're only going to be entitled to the qualified immunity, which, as I pointed out, still is pretty darn good. So while you do have these immunity doctrines at your disposal, there is a little bit of a trade-off as probation officers because you have what courts have called a special relationship with the parolees, and that could highlight your responsibility. That could make you vulnerable, to normally what is a Fifth Amendment claim. There is also something called a state-created danger theory, where the harm to either the parolee or others was foreseeable. That could also create an increased exposure to a Fifth Amendment type claim. The final concept I want to deal with here is the liability, is indemnification. So even if Department of Justice is representing you and it's one of these personal capacity lawsuits and they lose, it's still a judgment against you personally. So that's where the policy would kick in and provide judgment protection, depending upon if you got the $1 million or $2 million up to those limits. You also get those full limits to defend if we had to provide you representation. So this is just a fun little slide that illustrates that being sued is a little like walking into the lion's den. So the point is that a PLI policy just gives you that peace of mind that you'll be protected if that definitely does happen to you and DOJ declines representation. So just a quick civil recap. You can be sued. Get that out of the way first. You can be denied DOJ representation. You can be held liable for a judgment. PLI protects you in these 3 major ways. It provides a legal defense if DOJ declines to represent you. It may do coverage counsel if DOJ is on the fence as to whether they'll rep you or if we want to oversee the representation of you in certain kinds of cases. And then obviously it pays damages. So that's civil. The second coverage area is coverage for administrative matters. Now, as a court personnel, a lot of these aren't applicable to you. You're at-will employees. You don't have an IG. OSC doesn't have jurisdiction, but you are subjected to what we call administrative investigations into any potential violation of the Code of Conduct for Judicial Employees or really any other misconduct investigation. And the Fed's professional liability policy will pay for legal defense up to $200,000 for any one of these kind of administrative matters that could result in a personnel action against you. So, if it's an investigation, we would appoint an attorney to, get you ready to go through that investigation, possibly defend during the investigation if we're able to participate. If you're issued a disciplinary action, we would assist you. You do have a limited due process available for these job actions. So there is some process due. So it is beneficial to have an attorney help you navigate that process, even though that process ends at the court level. Now, it depends upon the court, but I have found that often, even though this process is very limited, that you're entitled to, it often can be meaningful due process. And whenever I'm given an opportunity such as today, I like to remind the management officials who are responsible for giving this process that it is important to make it meaningful, because when it's not, and everyone knows it's just a sham, I found it really impacts morale across the board. A great example I give is over at the CIA, for example. They have very limited appeal rights over there, but they have one of the most meaningful kind of grievance procedures around, and that's so it doesn't impact morale. So the cases where I see probation officers getting jammed up the most, are like lack of candor charges, false reporting, obviously failure to properly monitor, conflicts of interest, any violation of the code of conduct, which I know you guys, your chief assures me you guys know well aware of. If you're involved in anything, getting any significant notoriety or public attention, there becomes an overwhelming burden on the part of the organization, in this case the court, to assign blame and hold people accountable. So these are just some fun slides to illustrate the blame accountability point. I hope nobody is named Johnson in the room. And having your own attorney when this is happening to you is really the best way to defend against being made what I call the scapegoat here. I love this slide. So there are just two kinds of administrative investigations I want to mention. The first one, I'm not sure if it would ever affect court employees, but I just want to throw it out there. Is coverage is provided for any congressional oversight investigations or hearings, or if there's other kind of congressional or judicial hearings going on where you may be the subject of it, we would assign you an attorney to assist in that process if this does happen to you. The other investigation I want to mention briefly are EEO complaints for the managers in the room. If somebody files an EEO complaint, yeah, it's a complaint that's handled and filed within the court, not necessarily against you, and there's no real liability to you, but we like to assign counsel to assist with responding to these EEO complaints. Because often the system kind of operates separately from management. These EEO complaints, you just get notified that somebody has filed a complaint. Nobody really explains to you your role in the process, which is kind of to establish what we call the legitimate non-discriminatory reason for doing whatever it is you did or did not do. So even though these complaints sort of die at the court level, it can be important, to have your own counsel, just to provide, some basic advice in getting, if you're participating in ADR, it's good to have somebody to sound off on that. If you're responding in an affidavit form to the specific allegations, it can be good to talk to an attorney about that process as well. So the final coverage area is criminal, we're going to discuss. And I know most of you're all law enforcement officers, and you didn't come into work today intending to commit a crime. But as federal officials, you need to appreciate that there is very little you can do wrong in your job and not have it also be a violation of Title 18, which, as all of you know, is the criminal code. In fact, there are some statutes specifically for you under Title 18. There's Section 242, which is deprivation of rights under color of law. Section 241, conspiracy against rights. Section 245, which is federally protected activities. And there's an office here in Washington, D.C. called the Office of Public Integrity. I'm sure you've heard of it. But they sort of make it a mission to prosecute senior federal officials and specifically law enforcement officials because they believe that that sets an example in the tone for the rest of the government. So some of the most common criminal investigations involving law enforcement officers, conflict of interest statutes where intent is not a prerequisite to prove the crime, perjury, release of Privacy Act or other statutorily protected information, really any situation arising out of an allegation of misuse of position or abuse of authority. One example I like to give here, everybody probably remembers the Martha Stewart trial in New York City. There was a Secret Service agent named Larry Stewart, ironically enough, who was testified in the prosecution's case in chief against Martha Stewart. He was the polygraph examiner. And if you remember the Martha Stewart trial, the case was not about the securities fraud. It was all about whether she misled investigators during the investigation. So, the truth-telling part of it was the important point that the Department of Justice was trying to emphasize and prosecute. So in this case, Larry Stewart, they felt he perjured himself in the prosecution's case in chief. They turned around and prosecuted him for perjury. He had a PLI policy and was actually defended by my old law firm and was eventually acquitted, which is important to emphasize because, a cost of, for a criminal trial, can easily cost you $100,000, can easily be cost debilitating, for a lot of us. So that's one of the reasons that a policy is so important. If you are notified that you are a subject of a criminal investigation, it is absolutely important for you to talk to or retain a criminal defense attorney before you talk to anyone. It's crazy how many people who are in law enforcement I need to tell that to. If you get a target letter, if you're notified that you are a subject of some sort of criminal investigation, you really need to talk to an attorney before you start talking to anyone. Again, just another fun slide, that even though there could be a job action as an at-will employee taken against you, there still can be criminal exposure because, as I mentioned earlier, there's very little you can do wrong in your jobs and not also have it be a violation of Title 18. It's that broad. So let's just summarize what professional liability insurance covers. You have up to $200,000 for these internal disciplinary proceedings. Lawsuits up to the $1 million or $2 million to satisfy judgments and to defend in the case. And then in certain cases, a lawyer to monitor DOJ's representation of you. And then for any criminal proceeding, you have up to $100,000 to defend in any criminal charges. Other distinctive policy features I should mention is there's no deductibles if you file a claim. There's a free 36-month tail after you retire or otherwise leave your position for any civil lawsuits that may follow you into retirement. So that's the standard statute of limitation for any kind of Blvens action that normally would be filed. So you're protected and you don't have to buy the insurance into retirement. We also provide 2 free 1/2-hour legal consultations for pre-complaint matters or things that are, for things that aren't necessarily covered by the policy, such as medical retirement, if you had other kind of legal related questions related to your federal employment, such as fitness for duty, maybe performance-based stuff, any retirement type questions, workers' comp or anything like that, you'd be able to talk to an attorney. And we don't sit here and count those or time them. We'll give you whatever legal advice is necessary for a situation. It just means we can't enter an appearance and represent you for these things that aren't necessarily covered. So the cost, as you can see, the cost is pretty affordable, and if you're eligible for the reimbursement, it's only $145 annually for the $290 policy. I should mention that payroll deduction is available at $12 a pay period. With hourly rates, geez, running anywhere from $300 to $500 per hour these days for experienced lawyers, you can see how the legal bills can mount up pretty quickly. The cost of the policy costs less than 1 hour with an attorney usually, so it's very affordable. I want to briefly mention, because some of you in the room may be members of the Federal Law Enforcement Officers Association, FLEOA, and I briefly want to mention that there is some overlap in the benefits, and both FEDS and FLEOA encourage folks to have both. And the main point is your FLEOA membership does not provide coverage for civil suits and criminal investigations. Obviously, MSPB appeals don't apply to you, but the civil suits and criminal investigations are not covered by your FLEOA benefits if you are a member of FLEOA. Since we're talking about FLEOA, I should mention that we are recommended and endorsed by the Federal Probation and Pretrial Officers Association. If you're a member of that association, you get a $10 discount code, FPPOA. Same thing if you are FLEOA, it's FLEOA. And since everybody has spent time with me this morning listening to this presentation, if you're not a member of any one of those associations, you can put in the discount code FOF when you sign up. It just stands for Friends of Feds. So it's actually at the request or initiative of two probation officers, or several probation officers, that we added an optional coverage for LEOSA. So LEOSA stands for the Law Enforcement Officer Safety Act. And essentially what this allows qualified law enforcement officers to carry concealed their weapon off duty, notwithstanding state law. So we provided additional coverage to protect in any liability if somebody has to act in an emergency situation, act as self-defense, in defense of self, spouse, others, in any kind of emergency situation. Also provides a criminal defense resulting from that act of self-defense, and up to $25,000 for state charges regarding unlawful carriage. If you get cited for carrying concealed and your defense is, hey, I'm carrying lawfully under LEOSA, we'll defend that for you as well. And there is a lower limit here at up to the $250,000, and then the other legal defense limits are the same. So we are looking to increase these limits. I can tell you in the future. I can just give you a handful of examples where LEOSA coverage would have been important. Had an ICE agent down in Orlando, had somebody who helped him move a washing machine into his house, and the individual came back later at night, claimed he left his phone there and needed his phone. The officer went back and looked for the phone, couldn't find the phone, came out and told him, and then the individual pulled a knife on him, took his wallet, was threatening him. He had his pregnant wife in the house, and he said to the agent, now we're going to go inside and nobody's going to get hurt. And it was at that point the agent knew that something bad was going to happen if he went in that house. He was able to bend down, pull his service weapon out from his ankle holster, and he shot and killed the individual. The agency denied him scope for that, even though he was an 1811. They denied scope, and if he didn't have the LEOSA coverage, it turned out to be a clean shoot. There was no criminal prosecution and there was no lawsuit. But if it was, the only way he would have been protected would be through this LEOSA coverage. A lot of people are familiar with the case down in Virgin Islands, ATF agent involving Will Clark, who was going to the gym Sunday morning. And there was a domestic violence incident happening with his neighbor. Woman came running towards him, protect me, my boyfriend's trying to kill me. There became an altercation. He shot and killed the boyfriend. Now, ultimately, ATF did scope Agent Clark, but that was, knowing the intimate details of that was touch and go as to whether they were going to scope him. So it could have gone the other way. and without the LEOSA coverage, he wouldn't have been covered. The other case most people know about is the diplomatic security agent in Hawaii, Chris Dede, was at a bar. Him and some other guy, I guess, were trying to hit on the same woman. It carried over to a McDonald's. He ended up having, pull his gun on that guy, and he fatally shot him. Department of State, rightfully so, declined scope in that case. Without LEOSA, he didn't have LEOSA, so he wouldn't have had any particular coverage there. So there are all kinds of examples like that if you are somebody who does carry off duty. So over the years, I've found the biggest obstacle for folks making the decision to purchase professional liability insurance has to do with this belief that it can never happen to me. You guys are all dedicated, hardworking, law enforcement officials, doing things the right way. So I came up with this illustration. If you bought, and this was supposed to make this point, is if you bought the insurance for your entire career and you never used it, it's going to cost you, what, $5,000, $6,000? And all you did is have that peace of mind that you had it there in case you needed it, in case you were sued. That is not going to change your standard of living when you retire. That's not going to dictate what kind of car you drive. However, if you get caught having to hire your own counsel for what would have been a covered matter, you've got to pay thousands of dollars. When I was an attorney in private practice, I witnessed people, spending, hundreds of thousands of dollars, mortgaging their homes, bleeding out their TSP, to defend in a particular case. That could impact your standard of living, when you retire. So this is my final slide, and then I want to mention one thing. I know Kurt wanted me to talk quickly about GOVs, and I'll do that before I close as well. So this final point can't be emphasized enough. You need to have the coverage in place prior to the allegation or the claim or suit will not apply, okay? Coverage will not apply. I can't tell you how many people that I have buying the insurance, after their house is on fire. You can't get in a car accident on Monday, buy your insurance on Wednesday, and think it's going to cover you, on Friday. The time to buy the insurance is not after the National Weather Service, names the hurricane. It takes less than 5 minutes to get enrolled. Most people just go online, you do it right there. You get emailed your certificate of insurance. It happens instantaneous. It's effective immediately as soon as you pay. If you pay by credit card, you can send in, a paper application. It's one page. You can mail in a check. As I mentioned, there is payroll deduction available. Or if you want to just talk to somebody, you can give us a call. Anybody who answers the phone can take your order, can answer any questions. Now, before I conclude, there was I know Kurt wanted me to address briefly about the use of your own personal vehicles and performance of your job if there's if you get an accident or something like that. It's been my experience that that's covered by you're going to be covered by the Federal Tort Claims Act, so you would have absolute immunity for those kinds of accidents. The dicey thing happens if you're commuting as part of your job, either with a GOV or with your own personally owned vehicle. It's governed by state law as to whether that's within the scope of your employment. We typically tell people to get, the additional insurance, in addition to that. So that's all I have for today. I guess we'll open it up for questions.
Okay, you guys are off mute, so if you want to start facilitating questions, feel free to do so.
Okay, anyone have any questions for Tony? Mary Ann, step up.
Is the deduction pre-tax?
No, it's not. It's because we're not doing it through the government. It's you're setting up your own allotment, so it's all after tax. But it is, and I can't give you tax advice. Need to get that disclaimer out there. But it is deductible on the other end as a legitimate business expense, employment expense.
Tony, I had a question. Could you please give us some specific examples of probation officers being sued?
So the most common example is, sort of negligent supervision. Somebody's supposed to check on somebody, they don't, and then they commit a crime or they do something, or they put, one I'm looking at right now, they revoked his probation, and an altercation occurred when they were doing an arrest, and he died during the arrest, and they filed a lawsuit based upon that. It really primarily has, it ties to the core things that are your responsibility with parolees. So it's either when they're injured themselves, do something to themselves, a family member then sues, and says there's something different you could have done with the special relationship that you have, or they do something to someone else, and then a lawsuit, ensues. People can, sue for almost anything these days. They could try, like under 8th Amendment, cruel and unusual punishment. We see that often, when you revoke probation and things like that. But those are usually, court has uniformly, those are dead on arrival, pretty much.
How about with managers, Tony, as far as supervisors, deputy chiefs, as far as failure to train, failure to supervise, and things like that? Are they usually lumped into these suits?
Yeah, it could be. It's not the same, though, like for state officers under a 1983 action, where liability turns upon, what kind of training or supervision was provided to the state and local official. But so as a manager or supervisor, you can do something to an employee that could abridge upon their First Amendment right, for example, even though employees don't have the same First Amendment rights as employees as they do as citizens. It's somewhat limited, but you could do something that could infringe upon that. There could be a Fourth Amendment claim. If, say, you search an employee's workspace without any kind of reasonable suspicion. If you think an employee's drinking on the job, you don't have any, reasonable suspicion, and you kind of like search a locked drawer, you look in an employee's purse or bag or something like that, there could be a Fourth Amendment type claim. As far as the usual claims against managers, you see most frequently are EEO claims. That you're doing it, you're taking an action against another employee for something that is protected by, the Fair Employment statutes. Title VII obviously doesn't apply to the courts, but you've got something similar that they allow people to file complaints on. But the exposure is limited at the court level. Nothing ever really gets out of the court level.
Okay. What about for specialist positions as far as district firearms instructors, officer response training, and things like that? How about those positions? Are they much more liable?
All those collateral duties that someone may have, it's all covered. I get that question a lot. Like, I'm a firearms instructor, this or that. I mean, all that stuff. The coverage still applies. Yeah, the more responsibility you have, the more vulnerability you have. And this is kind of the point. I don't think I made very well in the intro about the three toys, the badge, the gun, and the car. The real thing there is the badge. So with your position as probation and pretrial officers, you have a tremendous amount of authority. And what comes with that is increased scrutiny. And it should, because you have the power, to deprive somebody, of their liberty. And when somebody alleges an abuse of that power, we ought to be, providing some scrutiny and looking into that. And then, so the more responsibility you have, the more you take on, it's just natural to assume, that there's going to be more scrutiny associated with that.
Tony, what do you have for representation throughout the probation system? Do you happen to know? How many members?
Our core panel counsel, our lead panel counsel is Shaw, Bransford, and Roth here in Washington, D.C. For employment-related stuff. for administrative stuff, for well over 30 years, they've been the leader, in the federal personnel world. And I get, the question I get a lot is, who do you have up in, like you would say, who do you have up in Rhode Island? Well, we do got counsel all over the country. But like I tell people is, you don't need somebody down the street to hold your hand. You need somebody who specializes in this nuanced area of the law, and most of those people are here in Washington, D.C. For civil liability stuff, we use Molo Lampkin, Dylan Kaiser, the Kaiser Law Group. Criminal stuff, we also use Molo Lampkin. We'll use Shertler and Honorado here in D.C. We for criminal stuff, tend to get former AUSAs. If it's, there are times, though, when we definitely need local counsel, if it's something where we feel it's important that they need to know the local bar, local judges, and we get referrals, all around for that. And if there's somebody, look, while we do select counsel, if there's somebody that you're already working with or you're comfortable with, we'll have that discussion with you. We just want to, because we're in it with you. We just want to make sure that we get the person that's going to provide the best quality legal defense for you, because at the end of the day, that's what it's all about when the stuff hits the fan.
Right. Do we have any other questions?
Can you explain who qualifies for reimbursement? Because you backtracked on that a bit. Is it all for
Yeah, so I was corrected. So apparently at most courts, only probation officers are eligible for the reimbursement. Pretrial officers are not eligible. But I guess each court can make that own determination. Given that you all have, for what it's worth, Kurt or John, if you're willing to take it up with the chief judge, it's essentially an appropriations issue. And, in the rest of the federal government, executive branch of government, you can only use appropriated funds for what's called necessary and appropriate expenses. And so, the law was passed to say this was a necessary and appropriate expense for these certain employees, managers, supervisors, law enforcement officers. And it's pretty loosely defined throughout the federal government. The courts are you guys are an island all your own. You get to really determine what is necessary and appropriate, and nobody is looking into that. So, for my money, pretrial officers are law enforcement just like probation officers. So there could be an argument to get the reimbursement, but we'll have a situation like at the Postal Service, for example, the Inspector General will reimburse its agents, but the postal inspection agents, who are more law enforcement, in my opinion, than the IGs, are not eligible for the reimbursement. So you could see little distinctions like that. If the leadership, is convinced that this exposure is still there, they can authorize it.
Yeah. In this district, Tony, we're all probation officers. We actually are a combined district, so we do pre-trial, pre-sentence, and supervision. So we'd all
okay, good. So, yeah, so you're all getting reimbursement. Okay, good.
Sorry, I could have saved you 5 minutes. I apologize.
No, and they ran in here, and interrupted me, and got me off my game too with that post-it note.
All right. Any questions before we let Tony go?
Well, you were asking him about
represent.
And I think that when it's a representation,
yeah.
But what about membership numbers?
Yeah, Tony, as far as membership numbers for the probation system, do you happen to have those? And that was my question before about representation, as far as, maybe.
Oh, that was your question. I'll have, I'll look into that for you, and I'll let you know.
Okay.
My sense is there's over 1,000. I would have to look.
Okay. All right. Sounds good. By any chance, are you guys going to be down at the FPPOA? The training in Orlando in August. I know.
I think we are going. I think either Brenda on my staff or Samantha one of those two are going. When is it again?
August. What's that?
Yeah, you can't get me to go to Orlando in August, but I can send one of my employees. It's hot.
All right. Anything else? Can you think of anything?
I have a quick question.
Hold on.
The increased policy, or the more expensive policy, provides an increased limit for the civil portion. Does it increase the limits across the board, or just only?
It does not. It does not increase the sublimits. So it really just increases the civil liability limits. The $200,000 for the administrative stuff is more than enough to get you through any kind of administrative stuff. And the criminal limit is really designed to go convince whoever's thinking about prosecuting you that, whatever's happened, they ought to decline. It's called get a declination of prosecution, and really work the prosecutor to decline and just let the court deal with whatever the issue is from an administrative side of the house.
Okay.
But it does not increase those limits, so that's a good question.
Thank you.
All right. Anything else? Tony, thank you very much for that presentation.
All right,
Really
guys. Thank you. Have a great week. Have a great week.
You too. Thank you.
All right, bye.
Thanks, guys.
Thank you.
See ya.